Now you can watch WHPR TV 33 on Fire Stick. Catch all of your favorites. Stay informed. Don't miss a minute of your favorite talk shows. Call, text, tweet, post. WHPR TV 33 is worldwide on Fire Stick. For more information, go to FirestickTVNetwork.com or call us at 313-868-6612. WHPR TV 33, a Watkins Broadcasting Company.
Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers, with Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?
Good morning. Welcome to Law Power Hour. Good morning, Jeffrey DeCoster. How are you?
Feeling good, Barry. Thanks for having me on.
Come on a little closer to the mic. It actually looks like I'm taller than Jeff here on screen, but the fact of the matter is he's about 6'4" and I'm 5'9", so we make an interesting couple.
Through the magic of television, as it were.
You got that. Jeff, where's your office located?
Bloomfield Hills.
And why don't you tell our listeners a little bit about your practice? What kind of practice do you have?
I have a general practice. I am primarily focused on dealing with individuals and small businesses. Typically, I have people coming to me in times of crisis. I run what's best probably described as a boutique practice. I'm the only attorney, and I've been at it for just under 25 years.
Well, in terms of a boutique practice, tell people some of the things you handle. I mean, I know some of the things you handle. We were going to talk about them. One of them had to do with homeowners' claims and who should be handling the homeowners' claim.
Oh, sure. I've had some experience dealing with public adjusters.
What's a public adjuster?
Well, public adjuster is an individual who oftentimes will appear on the site of a fire, for instance, a house fire. They'll show up, and at the time where the homeowner's the most vulnerable, and they'll have them sign a contract where the public adjuster promises to be the agent of the homeowner to secure the rights under the insurance policy in exchange for 10% of the gross value of the claim.
You know, I've heard stories, and I'm not really being silly when I say this, but I've heard stories about public adjusters having police scanners. And when they hear there's a fire, especially a house fire, they're often there at the same time the fire trucks arrive to talk to the homeowner.
Well, it's funny that you should say that. I was recently in a deposition where a public adjuster, in fact, testified that that's how he identifies potential claimants and claims for him. So they're essentially sales calls for the adjuster.
Yeah, and as a sales call, they come out there, and as you pointed out, people are the most vulnerable because they're terrified, aren't they?
Well, I think they're in shock, right? They're watching essentially their possessions and their mementos literally going up in flames, and then they've got somebody pestering them to hire them in order to secure financial advantage, or what they're representing to be a financial advantage over the insurance company.
Now, there are different types of coverage available under a homeowner's policy. There's a dwelling, there's contents. By dwelling, I mean the structure itself, correct?
Absolutely.
And one of the problems that you face as a lawyer when you're talking about structural damage is maximizing the claim, because oftentimes the insurance is not enough to cover the repairs in the house. Is that true?
That's correct. You're going to recover on your own without the assistance of somebody who knows what they're doing. You are going to recover what the insurance company is willing to pay you for what they think the value of your house is, or for what they think they can get away with paying you, and that what you will accept.
But your insurance contract may provide for a lot more that people don't understand that it provides for. For example, you have a structural damage and the house has to be demolished. There's demolition coverage in an insurance contract, isn't there?
There is, and there's also something called recoverable depreciation, or recapturable depreciation on the house in some of the policies, where if the repairs cost more than the actual value of the house itself, then you could recover that, but you're going to have to look to the language of the policy.
So on the recoverable depreciation policy, for example, if I have a loss, the insurance company holds back 10% under the recoverable depreciation portion of the policy.
Mm-hmm.
You can recover that if you do one of two things: rebuild the house or demolish it, right?
Or in some circumstances, purchase a house that is of higher value. We've seen that recently in a case.
Okay, here's the most important thing that I want to ask you. Should I, as a homeowner, if I have a fire or a flood, have a consultation with an attorney before I hire a public adjuster?
Absolutely. I mean, that's literally the $65,000 question, isn't it?
Well, yeah, that's the point. You added an extra few dollars in there, but it's okay.
Well, I'm not. My point isn't to suggest that it's going to cost the homeowner $65,000 by talking to the attorney. My point is suggesting that it may cost the homeowner $65,000 by not talking to the attorney.
Okay, and your point's well taken. And here's my premise. If you have a fire or a flood or flood damage, and you spend an hour with an attorney reviewing your insurance contract, and at the same time, if the fire adjuster or the property damage claims adjuster, whatever he or she wants to call themselves, has a contract, bring that in and have it reviewed at the same time. Then you know exactly what you're getting.
Absolutely. And I'm unaware of any specific educational requirements or any type of expertise that the public adjuster needs to have in terms of reviewing contracts. And I believe it's illegal for the adjuster to give a legal opinion regarding the construction of a contract. I think you need to go to a lawyer for that.
Well, here's the problem that I see. I have a flood at my house. I call up the insurance company. I give them notice of the flood. That's what I have to do under the contract, right?
Yes.
So after I give them notice of the flood, they give me a form. Is that what? And I have to fill that out.
Correct.
How do I know what I'm supposed to put on that form unless I get some assistance?
Unless you've had a previous claim or previous experience, that's a very good question.
And that raises a very interesting point. If you've had a previous claim, you're going to, more likely than not, be involved in giving a statement under oath.
Oh yeah, the statement under oath. That is the
Tell our
favorite
listeners,
of the insurance company is the statement under oath. A statement under oath is an opportunity for the insurance carrier to gather information from you as the claimant that is going to give them a basis to deny your claim. Having adjusted insurance claims for a period of time, I've participated in statements under oath and recorded statements where I've secured what are called admissions. And admissions, everything you say as a party to a lawsuit can and will be used in court against you as a party opponent admission.
okay, so if I have an insurance claim and I file my claim, let's take it step by step. I get a form from the insurance company, one of their adjusters, that's what they're called, they're adjusters, correct?
Yes.
Gets on the phone and says, hello, Mr. Keller, how are you? I work for ABC Insurance, and I want to arrange for a meeting with you so I can take a statement from you. What should I do?
Well, I think that you're probably best served by getting some advice from someone who is familiar with the process, because under a lot of insurance policies, that is a precondition to any claims being paid.
What do you mean by that?
That means if you refuse to give them a statement or a statement under oath, or refuse to communicate with them concerning the facts surrounding your claim, that they may be able to not deny your claim in its entirety.
Okay, so the statement under oath is taken, and I provide them with all the information. I feel very comfortable. I've given them all the information. Then I make my claim, and my claim's different than the statement under oath. What's going to happen?
Well, they're going to claim that at least one of those statements or the document where you make your claim is somehow untrue or fraudulent, and they're going to deny that part of it.
So should I have a lawyer when I give a statement under oath?
I think it makes a lot of sense. You'd be best served at the very least, by talking to a lawyer before you give a statement under oath.
Do lawyers charge a lot of money for that? I don't know how much they charge for that.
It all depends on the lawyer, right? Lawyers are a lot like auto mechanics, and people come to us and they're very vulnerable, and some lawyers will charge a lot of money, so other lawyers won't, and it is, it's hard to say who's going to charge what, but, if you're talking about reviewing an insurance contract, I wouldn't think it would be unreasonable to pay for an hour of the attorney's time.
If I wanted to call you and hire you for an hour, how do I get a hold of you?
You can call my office,
What's your number?
248-799-9230.
Would you repeat that a little slower?
248-799-9230.
So when you review the insurance contract, are you going to explain to me everything in that insurance contract that applies to my claim?
Absolutely.
I'm going to give you a example. We had these big winds, in the last couple months. We've had ice and sleet and problems in the last couple weeks. Good morning.
Good morning. You guys were just talking about statements under oath, and I have a friend that just had a statement under oath taken, and they were asking him questions about his child support, his credit cards. About things that I thought were not even relevant to the fact that this guy had a fire in his house. So could you address exactly what they're allowed to ask under these statements under oath?
Thank
I'll
you.
listen off the phone. Thank you.
Okay, now, we're going to use this question, but we're going to put it in the proper context first. So we have a fire, not a fire, we have a storm, and we have the ice problem, and I have an old tree in the backyard. It's a nice tree. I like the tree, but the tree's limbs fall on the roof of the house. So I want to make a claim, and I need to have the damage to my house repaired, and I want to do something about the tree. Am I entitled to do something about the tree?
Depends on your policy.
Okay, so I come in and see you. I review it with you. Then after I review it with you, I fill out a claims form, and the insurance company wants to take a statement under oath. So while they're taking the statement under oath, they start asking me all these other questions. Like the listener called in and said, what about the friend of the court? What about mortgages? What about credit? This, that, and everything else. Are they allowed to do that?
Well, they can ask you any question they want, you know, and I believe the state of the law right now is a substantial performance standard with regard to the statements under oath, where you have to substantially perform. It may cause you more problems not to answer the question, and they're going to make it uncomfortable for you, but if in some certain circumstances, you're better off just answering the questions.
And if you answer the question, should a lawyer be there with you so that they can at least raise a question as to the propriety? In other words, say, hey, you know, you're asking this question, but in a court of law, this would not be admissible.
Well, certainly, and I think it's also beneficial when we have situations when we're involved, say, in a deposition, where we've got a client that doesn't understand the import of the question, and where we have the opportunity on cross-exam to actually have that client explain what they meant by a particular answer. Because, as I said earlier, I believe that everything that you say as a party is going to be used against you, if possible, under the evidentiary theory of it being a party opponent admission.
You got to explain that for
Okay.
me. I don't understand it.
The party opponent admission, going back to law school and the rules of evidence, generally people talk about hearsay and things that are said outside of court by third parties. There's an exception to the hearsay rule for something called a party opponent admission. So what the insurance company will do is they will say in the lawsuit that you, as the claimant, are the party if you sue the insurance company. And anything you say outside of court as a party that's advantageous to the insurance company is going to introduce into evidence against you at the time of your trial. And it is not subject to what's called the hearsay rule. So I kind of flippantly tell people that anything you say can and will be misconstrued against you in a court of law, and you need to be careful about the statements that you make.
So one of the problems that I see is if you don't have representation, a skilled claims person from the insurance company has an opportunity to investigate you.
Absolutely. They have an unfettered opportunity to investigate you.
And therein lies a problem,
Absolutely.
because they're nosy people and they're getting into areas where they shouldn't go.
Well, and that's what these people do for a living. They're not there to maximize a claim, and the insurance company is not in business to pay claims.
Which leads me to the following question. Would you agree that if you don't have representation, that the insurance company is going to control the entire playing field?
Oh, absolutely. Absolutely. They're the ones with the money. They're the ones that are in control. And even with the public adjuster has no real means to compel the insurance company to pay your claim.
Okay, Here's the problem with the public adjuster that we have to address. I have a fire at my house. It burns down. I'm in debt. Someone raises the issue as to whether it's arson. I've got to go through an entire process to prove that I didn't deliberately start the house on fire, don't I?
That's correct.
I could be charged with a crime.
Absolutely.
And if I'm vindicated, I'm found not guilty, or they drop the charges, I'm still facing defenses raised by the insurance company.
Absolutely.
Civilly, they can say that I did something wrong that caused the fire, correct?
Yes.
And they could try and deny the claim.
Yes.
Okay, so that's the first hurdle. That's the cause of the fire that we've got to get over, right?
Absolutely.
Okay. So when we get over what we call cause and origin, as to how the fire started, who started it, and for goodness sakes, for those of you out there who have friends that have gotten in trouble, it's because scientifically today, insurance companies will spend a lot of money to prove cause and origin is not the result of a natural occurrence. Would you agree with me?
I would. You know, in the arson situations that I have seen, they have not been very sophisticated. Generally, they're not very sophisticated, and what happens is you'll see a fire with multiple points of origin, or they'll detect petroleum distillates in the residue from the fire.
Which means that there's a tracing across the floor.
Absolutely. Or if you use gasoline as an accelerant, what happens is the fire burns hotter than the rest of the house, and it's very easy for them to tell generally.
Okay, now, we got over those hurdles, and we get down to paying the claim. So if I tell them that I've got a fur coat, they're not going to believe me unless I can what?
Produce a receipt. That's the the single most and laughable requirement that I generally see, and I think what happens is a lot of people who live in impoverished areas are penalized for that. There seems to be.
I want to hear that again. Poor people are penalized for having insurance contracts, correct?
No, poor people are penalized by this notion that they're not allowed to have nice things. And what I've seen on multiple occasions is that people who are living in the inner city who may enjoy having some nice property, when it gets burned or it gets stolen, the insurance company says, well, you have to have a receipt for it. You know, and it doesn't matter if it's a family memento. It doesn't matter if it was a gift. It doesn't matter if you paid cash for it. You better have a receipt. And I can tell you that if I were to have a fire and someone asked me to produce a receipt, I would be in big trouble.
Well, I was reading an article some time ago, and it says the best way to prepare yourself for a catastrophic event is to have an inventory. And I sort of chuckled. I don't know of one person who has an inventory of the items in their house. Do you?
Outside of somebody who may be a collector of something, say, as valuable as art, where perhaps they don't have it on display, but they just have it available to them, I would say no. But, you know, I was just involved in a statement under oath situation where an individual had an apartment in Corktown, and he had a bunch of designer clothing, and he gave a statement, and I think that the attorney who was taking the statement was somewhat amazed and somewhat incredulous as to his claims until he started pulling out photographs of the items that he had. And he had Cartier sunglasses, he had literally piles of Ralph Lauren clothing, right? And he had jewelry, and it was amazing to me that he had pictures of all of these items. Because what happens is, again, you've got a guy who's living in an apartment where he's not paying much in the way of rent, but he has some very valuable equipment in there. And the insurance companies are very slow to recognize that people who live in the inner city have nice items.
Okay, we got a caller. Good morning.
Good morning. This question's for Good morning. This question is for Jeff.
Go ahead.
Thanks. Thank you.
I have a question.
We can't hear you, sir.
Can you speak up?
How do I make a claim for damages regarding a flood?
Okay, you had a flood?
Yes,
Okay, how long ago did you have the flood?
about 3 months ago.
Okay, did you contact the insurance company?
Yes,
And did they give you a claims form?
yes, but I'm suspecting they're not acting in good faith, insurance company.
Do you have flood insurance as part of your policy?
No,
That's going to be a problem. Do you own your house?
yes,
Well, if you don't have flood insurance, you're probably not going to be able to make a successful claim for flood damages based on your homeowners. How did your house flood?
some pipes were frozen and they busted.
Were those city pipes?
No, inside the home.
That presents a pretty difficult situation. What do you think, Barry?
Well, I think you should consult with a lawyer with your insurance contract. Because remember, when you buy an insurance contract from an insurance agent, they're just selling you something. They're like the front end in a restaurant when you go in there. They give you the menu, you look at the menu, and you pick out what you want, and the people in the back are taking care of business. I'm real serious about what I just said. So you got to talk to somebody about this. You ought to give someone like Jeff a call.
Definitely. How do I get a hold of Jeff?
Go ahead, Jeff.
Go ahead and give me a call. My number is 248-799-9230. If you bring your policy in, I'd be happy to take a look at it for you.
Thank you, gentlemen.
You're welcome. Have a great day.
Thank you.
You too. Bye-bye.
On that note, we're going to take a break for a minute. We'll be right back.
Are you in legal trouble? Are you in need of legal advice? Or just have general legal questions? Call 1-800-529-8721. That's 1-800-LAW-USA1. And watch Law Power Hour and get your questions answered by experienced attorneys who are experts in their field. That's Law Power Hour, hosted by Barry Keller, attorney at law. Saturdays at 10 a.m. here on WHPR Detroit Live.
Legal Lockbox provides you with 24/7 secure cyber access to all of your sensitive legal documents. No more waiting for the bank to open to access your safety deposit box. All of your important legal documents are available at the touch of a finger on any connected device. Whether you're traveling, faced with a medical emergency, struck by a natural disaster, or just living everyday life, having access to your most important personal files and documents won't only save you time, but it will give you peace of mind as well. The need to access our important personal documents can arise when we least expect it. From birth records to insurance papers. With Legal Lockbox, you can have access anytime, anywhere to all your personal, professional, and legal documents. On a family vacation? Where are your records? In a car accident? Where are your records? Flood damage? Where are your records? Fire damage? Where are your records? With a loved one in the emergency room? Where are your records? Need immediate access to your power of attorney? Where are your records? Legal Lockbox will store your documents in a secure, encrypted cloud service. When you need access to them, our two-factor authentication provides you secure access to your account. Our cloud service gives you maximum security for all of your personal, professional, and legal documents. No matter where you are, no matter the situation, Legal Lockbox can securely bring you all of your important files to any connected device. Legal Lockbox. Where are your records?
Now you can watch WHPR TV 33 on Fire Stick. Catch all of your favorites. Stay informed. Don't miss a minute of your favorite talk shows. Call, text, tweet, post. WHPR TV 33 is worldwide on Fire Stick. For more information, go to FirestickTVNetwork.com or call us at 313-868-6612. WHPR TV 33, a Watkins Broadcasting Company.
Someone who had a fire and they were a tenant living in an apartment and they didn't have renter's insurance. Is there such a thing as renter's insurance?
Absolutely. I would advise anyone who rents a premises to have renter's insurance, since they have a responsibility for the interior of their apartment generally.
So in other words, if the building burns down, the landlord is not responsible for my contents. Is that true?
That is true.
So if I have renter's insurance, what's going to happen?
Well, it's much like the homeowner's insurance, except it doesn't cover the structure, it covers the contents.
And again, in that claim you handled for that fella in Corktown, was that person a renter or an owner?
He was a renter.
And he had renter's insurance.
He absolutely had renter's insurance.
And he did the smartest thing in the world. He took his camera out on his phone and he took pictures of everything that he owned in the apartment, correct?
That's correct.
Did you solve the claim?
It's pending right now.
Okay. I don't want to put you on the spot, but he also has to prove that he purchased the items that he's shown in the picture, correct?
Well, I don't know if he has to prove that he purchased the items. He has to prove that he owned the items.
Okay, that's I guess another way of putting it. Well, now that we're talking about homes, homeowners, insurance, there's a real big issue that I've talked about in the past, but never really got everybody to understand. I own a home, and I'm getting up in age. I have Medicare. I could end up in a nursing home. I want to transfer title to the property. Do I need to do that to protect the family?
Who do you want to transfer title to?
To my son. How do I do it?
Well, I would advise that you don't transfer title to your son outright, and there's a number of reasons for that. First of all, if you transfer interest to your son, you may be creating a taxable event that's unanticipated. If you give him property outright, you may also be subjecting your property to the claims of his creditors if something were to happen. Say if he were in an automobile accident and he didn't have insurance, you could be finding yourself in a situation where your home is at risk. But more to the point, if you're someone who's aging, in these times that we have now, we see people that are suffering from illness that may require extended stay in a nursing home or a rehabilitation type situation, and they may need to qualify for Medicaid. Unfortunately, there's a lot of people that may need to qualify for Medicaid, and if you simply deed your property to a family member, you will be penalized for what's called divestment. And what divestment provides is if you give the value of your property to a third party without receiving compensation for it, that's reasonable compensation in the marketplace, the good folks at Medicaid will treat you as if you basically took money that you could have paid your nursing care with and just gave it to somebody else. So they will penalize you for the value of those dollars to an amount equal to what it would have cost for that Medicaid. So it's kind of a long-winded explanation, but
Give us a short version that we'll understand.
the short version is something called a ladybird deed. And a ladybird deed is a deed where you reserve for yourself the right to live in your house for the rest of your life. Actually, you reserve the right to own your house for the rest of your life. You are on title, as a title holder for something called a life estate, and you would put your child on there as someone who would have what's called a remainder interest, which means when you die, they would take your house. Now, the thing that makes the ladybird deed special is that nothing permanent vests in your child that can't be revoked. You retain the right to revoke the remainder interest from your child if you want. You can cancel the ladybird deed if you want, and it won't be subject to Medicaid concerns for purposes of divestiture.
Okay, let's stop the train for a minute here. That's a nice way of putting it. Okay. You're going on and explaining something really important. But I'm going
Absolutely.
to break it down into a few other land transfer issues. I have a house. I go down to FedEx. I get a form called a quitclaim deed.
Mm-hmm.
And I transfer the house to you by quitclaim deed. Once I do that, you file it. I can't get the property back, can I?
Not without paying me a lot of money, probably.
Because I've transferred title to the property.
Absolutely.
And I've transferred it, and it's not revocable. In other words, I can't turn the transfer around, correct?
Correct. Unless I'm willing to transfer it back to you.
Okay, so that is what we call an irrevocable transfer of property, correct?
Absolutely.
Okay. I transfer the property by a ladybird deed, and you're my son, then I can tear up that document because the title doesn't pass until something happens to me, correct?
Yes, I would only have an expectation of receiving that property if you don't revoke the ladybird deed during your lifetime. So say somehow I fall out of favor with you and you decide that you're going to disinherit me, you could simply revoke the ladybird deed.
Can I have more than one beneficiary on a ladybird deed? I've got 4 children. Can
Absolutely.
I have 4 children on the ladybird deed?
Yes.
Okay. Now, here's the big ticket question. Can the 4 children own the property with me, or do they only receive it upon death?
They only receive it upon death pursuant to the ladybird deed.
Okay, we've got a caller for a moment. Good morning. I knocked them off. Whoever was calling me, please call back. I hit the wrong button. Now, we'll get back on this question here very quickly. So, here we are. So, I've got the children's names on there. They get the title to the property if I die, correct?
Yes,
If I'm in a nursing home, it doesn't transfer to the children. It's still in my name, correct?
that's correct.
I die, it goes to the children.
Right.
If I put the children on as tenants in common, what does that mean?
That means that they have an undivided ownership interest with you in the property.
So if I have 4 children and they're on there, all 4 children would have a quarter interest in the property if I died?
Theoretically.
If I did it joint tenants with rights of survivorship, which is very common, what would happen?
Well, with the joint tenants of full rights of survivorship, I mean, it's kind of technical. It's a creature of statute in Michigan, where you have life estates and remainder interests again, but it's not revocable, as is the ladybird deed.
Okay.
But what the difference is with the joint tenancy is the inheritability of the interests. So if with your children being joint tenants, if one of the children dies, their interest in the property would pass to their heirs or people that are listed in their wills. If the joint tenancy, that they're all joint tenants, when one of the siblings dies, their interest would automatically merge with that of the other living siblings.
Good morning.
Good morning. Here's my question. So, I own a house. I have a son, and I got married. But I owned a house before I got married, and I want to quit claim the deed to my son and myself and leave my current husband out. So if anything happens to me, it goes straight to my son. Can I do that with what you're talking about, a ladybird deed or whatever?
Absolutely.
And there wouldn't be any problem with the fact that I'm a married woman and that my husband has some kind of right to it.
Well, what you're talking about there is a creature in the law that actually no longer exists. It's called dower and curtsy. It's my understanding it was abolished.
That's correct.
The only interest that your husband may have in the property is, since you've become married, if your husband is involved with, there'll be something called a coverture portion of the value of that particular property, meaning the increase in value during the marriage, unless it is determined to be your separate property, which is kind of a separate subject here.
Okay, but for clear deed, I'm okay with doing what my plan.
Yeah, absolutely. The nice thing about that is that it also avoids probate, and that's kind of the reason most people do it. How old's your son?
My son is 17.
Okay. So the
So
other
I just wanted to make sure that I could avoid probate and not have problems with the deed, or my son wouldn't have problems with the deed after I pass.
right, it is a probate avoidance mechanism. If you properly
Okay,
do
thank
the
you.
ladybird deed, there will be no probate of that property.
Okay, thanks.
Okay, so would you recommend to all of our listeners who are homeowners, I know I said this slowly, but would you recommend to all of our listeners who are homeowners, who have children, that they use a ladybird deed as a form of insurance in the event that they get sick, to protect their investment in the home?
I would recommend that all of your viewers consider a homeowner deed, but the circumstances for the application of the homeowner deed, the ladybird deed may vary in terms of the estate planning for the particular individual. But by and large, we see the ladybird deed used as more often than not as a very big part of a estate plan for ordinary people.
Yeah, ordinary people, if they get sick and they have to go into rehabilitation and Medicaid gets involved, Medicaid can look back 5 years to see what happened to their property.
Right. I believe they may have even extended that to as far back as 7 years. I'd have to review the literature. But the other thing that they also are going to want is probably a power of attorney, because you see people that are recovering from longer illnesses these days. So typically, when you're doing a ladybird deed with the attorney, part of the estate planning routinely is a medical power of attorney and a financial power of attorney. And typically those are durable powers of attorney, which are a special power of attorney that we have in Michigan for people when they get sick.
And by the way, listeners, and this is really important, a few years ago, I had a client who went to the hospital. He had bypass surgery, and then he got sick in the hospital and had an extended stay. His veterans checks were coming to the house. His daughter was supposedly depositing them in the bank to pay the bills, but instead she was having parties at the house while Dad was in the hospital. When he came out, the house was in foreclosure. So a word to the wise. get a durable power of attorney, place it in the hands of someone you trust, and authorize that person to deposit your retirement checks in the bank and have direct deposit to make sure that your mortgage is taken care of, your ongoing expenses are taken care of, so that if you have an extended stay, you're not going to come home to a nightmare and a notice on your door that your house is being foreclosed.
Yeah, and there's a very good practice with the financial power of attorney is to put one on file with your bank. That way they will not be surprised when somebody comes into the bank representing themselves to be your power of attorney.
Will banks take them?
They will.
Okay. So how do you handle these matters? If I want to come in to your office and I want these documents prepared, how long does it take? How much does it cost? And how do I get a hold of you to get it done?
Well, it's a simple office visit. You come in and provide information regarding the individual that you would want to be your attorney, in fact, as they call it in the law, or your agent.
We have a call coming in. Good morning.
Good morning. I would like to ask the attorney a question.
Yes, go ahead.
I have a friend that she has a home in North Carolina, and her husband had passed, and they had the home still, and her name was not on the property, and he has children by a former wife. Now the kids want her to sell the home so they can get part of the property. Is there any way anything she could do about that?
Well, that's an interesting question. Because first of all, if her husband owned the house in his own name before he was married, and then he got married and he had children from another marriage, his present wife would have an interest in the property, and his children may also have an interest in the property, depending on the value.
Okay.
But they should consult somebody like Jeffrey DeCoster to discuss the issue. He can explain it to them. Tell her how to get a hold of you, Jeff.
You can contact my office at 248-799-9230.
Can you repeat that, please?
Repeat it.
248-799-9230.
You just pointed
Okay,
out,
I'm
and
going to have her to give you a call Monday.
I appreciate your call, by the way.
Thank you so much.
You're welcome. Now, this is a very important issue. Second marriages, where one party already owns the real estate before they get into the second marriage, and their children from the first marriage, and the rights of inheritance, because the probate code specifically covers the rights of inheritance in this situation. Is that correct?
Absolutely. In the absence of a will, there's something called the statutes of intestacy. I think that's what you're referring to.
Right.
And the statutes of intestacy provide for a distribution of your property if you don't have a will. And I believe your comment regarding the value of the estate has something to do with the dollar figures that are involved, and generally what you'll see is there's a distribution to the surviving spouse and then to the issue, which would be the children.
Right, so they all may have claims, but in varying degrees.
Absolutely.
And you have to consult a lawyer to go over this. It's a little complicated. These problems can be avoided. These problems can be avoided by planning ahead. And that's one of the issues that we always talk about on this show, is planning ahead, which leads me to the following and last subject I want to talk about today with you. Do you know who your lawyer is?
Absolutely, I know who my lawyer is. It's my wife.
I know your wife is a lawyer. But you know what I'm saying. I call up 1-800-HENRY.
Right, right.
Okay, and I say Henry There's no such Henry person here that I know of. And when you call up 1-800-HENRY, are you getting Henry or are you getting somebody else?
Well, I guess it all depends how successful Henry is, right? But generally, you're going to get somebody else. You're going to get a frontline screening person who's going to decide whether or not you're worth Henry's time to talk to the second line person at Henry's firm,
Or
third line person.
somebody that Henry farms business out to.
Absolutely.
You know, there isn't a week that goes by that I'm not contacted by a marketing service, 1-800 something.
Right. I get called all the time by Legal Match, and they claim that they have clients, which they don't. They are not allowed to have clients because they're not attorneys.
Okay, so what we're trying to tell you folks out there is that there are a lot of marketers out there who are marketing for your business and getting a piece of the action, and they don't know the first thing, or as we would say, a hill of beans about what's going on in the practice of law. So you got to know your lawyer.
Absolutely.
So when Legal Match calls you, what do?
I generally hang up.
And tell the listeners why.
Well, they are not attorneys, and basically what they're doing is they want to charge me money to review your cases.
Good morning.
Good
Hello.
morning. Good morning.
How you doing?
Good. I have a question.
Hope so.
I have a question.
Go ahead.
If my wife passed and there's a property, anything of value, would the kids have any say so in the value?
Is your wife?
Yes.
Is your wife from your marriage with your kids?
Yes.
So there's only one family with the issue, correct?
Right.
Okay. The property would generally pass to you as a matter of law unless she had designated specific bank accounts with the children's name on them, holding them in co-ownership with her. She can't do that with her pension because under the ERISA laws, she can't name her children as beneficiaries. If she's married, she's got to list you. That's what the law requires. So if you're having an issue, why don't you share with us what the issue is?
Well, that is on the issue. The children is saying they're entitled to a part of whatever we had accumulated together.
You know, it's like the old golden rule. The person who has the gold calls the shots.
Okay.
Now, you're in charge. Now, if you want them to have something, you can arrange for them to have something today, tomorrow, or in the future. And that's why you should sit down and talk to an attorney who can help you plan it, who can answer your questions, and can make everybody nice and comfortable. See, the real problem is when somebody dies, all the relatives have an expectation that they're entitled to something. And it's a wrong expectation. It's the wrong belief. And it has to be straightened out because some folks really get angry about it. I just had a situation where people were married for 67 years. Can you imagine this? 67 years came in and they drew up their will, they drew up their paperwork, and one of the issues that was raised is that the granddaughter who'd been helping out at the house thought that she was entitled to the house. So I said, no, she's not entitled to the house. She's being compensated. And Grandpa said, well, I've got this old vintage vehicle. I said, well, if you want to give it to her, that would be very nice. It was a suggestion. He discussed it with his sons, came back in, made the decision to leave it to her when he dies. So the point is, you're in charge. You make the decisions, and don't let anybody get close to you and make the decisions. You've got to be the master of the ship. Okay?
Okay, sir.
Okay, Jeffrey, tell them how to
thank
get
you.
a hold of you.
Thank you.
You can reach me at 248-799-9230.
Well, it's been fun having Jeff with me. We go fishing together. He's a great fisherman. He's a bear hunter. He's an interesting guy, and we're going to have him back again. Thank you for coming.
I did have just one comment, Barry. I have a simple question for you.
Sure.
Are you a turtle?
You bet you know what? I am. Thanks for listening to our show. We'll see you next week.